Okay, now we're going to open up for questions. These guys are in the hot seat. Be kind to them. And I'll change the slide as well. There we go. Okay. So any questions in the room? And Camilla, if there are any questions online, you can also send them to me here.
Thanks, As. This is a very interesting overview. I follow EU matters for more than 30 years and I learned a lot. So thanks for all the insights. Of course, I know the EEA is very specific, but still it is fantastic to see. But I still have quite plenty of questions, but I will try to limit myself because there are some things which you say which, raise for me some inconsistency. So I'm coming from a think tank, SEPS in Brussels, where I work since a very long time. So I'm basically passionate about European policy issues. You say in the beginning, look, we remain sovereign. But on the other hand, you fully follow, to some degree, EU competition policy, or you fully implement EU laws overall. Or you still, which I, for example, didn't know, you say, look, we assess every Commission regulation, directive, whatever, and then you still decide. But I just wonder on what basis you decide to take something and not to take something. But also, if there are, for example, EU competition issues which are decided by DG Comp or by the Commission and which have an effect on the EEA, how do you interact? Because you say we remain sovereign. And you would say in certain cases, no, we don't agree with this. So I don't fully understand the process where you say, look, we remain sovereign, but on the other hand, we basically incorporate almost everything. And if you could enlighten a bit, let's say, what kind of measures do you use? Of course, there may be rules which are not applicable to the EEA countries, but there are certainly other ones where I think which will be applicable, could be applicable in the EEA countries, but where you say, no, we don't want them. Thank you.
Thank you, Karl Mare. Do you want to take this one? It's a heavy one, and then we'll go to another one.
Thank you. Thank you so much. Yeah, it's a very good question, and I understand that this is not always very clear to understand. I think it's important to remember that the agreement that we entered into, or when I say we, I mean our member states, entered into in '92 had its framework. So as a starting point, whatever EU legislation which is clearly within that framework, it's already agreed upon that we should take in. That is a starting point. And this is what my colleague Olli was also talking about, the EEA relevance. So if it is within the framework, our parliaments have already agreed that this is something that should be taken into the agreement. When we assess the agreements, what we have to assess is exactly this. Does this particular legislation fall into the framework of the EEA agreement? And as we have also touched upon a bit today, we also see that sometimes legislation have elements that are outside the scope of the EEA agreement. Then sometimes we ask for exemptions, or if our member states agree, you can also agree on between the parties. Then, of course, the EU side also have to agree to have cooperation outside the core area of the agreement. So there are many ways of incorporating. And yes, I agree with you. Some policies our countries also agreed to join. Sometimes that is also a cooperation outside the EEA agreement. I mean, on climate issues, for instance. So there are many ways. I mean, the agreement is a somehow fixed cooperation, but then you can also do inside and outside. When we have to assess each and every one, it's also because if the Commission has been given powers, very often the EFTA Surveillance Authority takes those powers. And then very shortly on the sovereignty, it's a part of this, but it's also what Olli was mentioning about the constitutional requirements. Because when we accept those legal acts, it still has to be accepted by the parliaments if it's not already in the scope. You want to add something?
We have another question here. Just introduce yourself with name and where you come from.
My name is it working? My name is Jim Eady. I work for two Westminster parliamentarians from Scottish constituencies. My question builds on the very good question and the excellent answer that we've just heard, and it is about the fact that in the UK there is a perception, or perhaps more accurately, a misperception that EFTA member states are rule takers rather than rule makers. But clearly, as the presentations have alluded to, this the reality is more complex than that. But my question is, can you point to any concrete, specific examples where EFTA, through the ability that it has to take part in decision shaping, has been able to adapt EU legislation or to achieve opt-outs from EU legislation to best represent the national interests of the EFTA countries?
Yes. Very good question. I think, Trond, do you want to be the one to take this one?
Should I jump in on that one? Yes, I think like these questions are very good, of course, and just since you mentioned then the decision shaping part, for instance, when we are trying very early on to see, like, to influence the outcome of things, of course we're going to discuss more about that in the workshop, but we do have, of course, concrete examples. For instance, when you look at the list of critical raw materials, for instance, where we argued very strongly, for instance, to include aluminium on that list, for instance, we see that's the final outcome. You have other examples, for instance, on some of the digital regulations, for instance, where it comes to how the big platforms, for instance, should treat consumers and what should be the mechanisms, for instance, for removing illegal content and these type of things, where we have kind of a lot of experience in influencing it. But I feel your question is kind of a bit in the borderline as well when it comes to the acts that we are actually then incorporating, and we're moving into that area. What kind of adaptations do we actually get when we take those legislation into the EEA agreement? And there, of course, there are a lot of, we've seen that recently as well, for instance, from the EU, there comes a lot of proposals as well, and they're in the final versions as well, when there's more kind of centralized enforcement by the EU side. So the commissions are giving powers actually not only to fine companies perhaps, but actually also to impose kind of structural remedies on companies. We've seen that with the Digital Markets Act, for instance, and we see it with the new AI Act. We have a new AI office, or the Commission as well is going to have some centralized enforcement. And there, of course, we have a need for kind of adaptations, which then somehow involves the EFTA Surveillance Authority carrying out those concrete surveillance tasks. So it's a bit, yeah, I'm not sure. Any additions or?
Okay, we have time for one more question from the audience, if there are any hands up. Yes.
Sure. Hi, thank you for really interesting presentations. My name is Linn Haugåsen, and I work normally for the Norwegian Consumer Council, but now I'm seconded to BEUC, which is the European Consumer Organization. And I just wanted to pick up a little bit on the last point here, because as you say, Trond, there's a lot of new regulations coming from the EU on the digital in the digital sphere, where the Commission is granted a lot of power to enforce, but also to make new rules as we go and adapt the regulation as they see fit. Also because in the digital sphere, there's some very, very big actors that are very hard to kind of control. Do you think, or the idea is essentially to have the EU have one actor who can enforce everything because it's so hard? And then do you think it's also feasible for EFTA to have a secondary enforcement? Or do you understand what I'm trying to ask? Like, do you think it would be possible for the EFTA or the EEA agreement in these countries to actually enforce against Google, let's say, as an example, any of these big companies? Thank you.
Again, a very, very good question. And I can't, of course, now move into any detail, because as we've gone through here, like this is now exactly these files you're referring to, of course, they are subject to our negotiations and now deliberations with the EU side. I mean, I can talk about what we are proposing and what we are looking at, and then, of course, that's kind of up to what we can agree on together. But just like as a general point, it's a development, of course, that we are seeing, and it's coming in several areas as well. The General Data Protection Regulation is coming up for review as well, and we don't know what concretely is going to be proposed there as well, but we might see this in other areas as well, that is going towards more centralized enforcement. And I can only say that we have, and which has been introduced as well, this two-pillar structure, of course, on the EU side. The EU side is also aware of that. I don't think we should sometimes we forget that, for instance. They also know that that is the way we are set up. So it's not kind of an answer to your questions, what's possible, not possible, what will be the final outcome, but it's more kind of some reflections on kind of the actual kind of discussions and deliberations that we have to enter into.
Trond, are there any examples already? I mean, now these laws are coming into play, but you know how the member states, for example, or the EEA EFTA states are regulating the GDPR on companies. Is there any examples on that?
Well, some of our authorities, right, are kind of taking the lead in some ways. You've seen that from the Norwegian Data Protection Authority, for instance, towards Meta. It's a case that's ongoing now, of course. So again, it's an example, I think, that when we have taken important legislation into the EEA agreement, of course, we are all playing by the same rules, and we have the same rights, our authorities as authorities in the EU member states. And sometimes in some areas as well, we are kind of a bit on the forefront, perhaps, when it comes to enforcement. So,
Mari, do you want to add anything?
No, I think. No, I'm joking. No, I think this is correct, and what we can say. Of course, these are things that are being assessed, but it's a good question because this also shows. I mean, this is a common responsibility. I think that's important. I mean, the agreement has its scope and it has its limits. The Secretariat is there to sort of assist and facilitate for those discussions. It's up to our member states to agree among each other, and then eventually also have that discussion with the EU side. And I mentioned in my intervention earlier that, for instance, on the EU agencies, we are participating in many of them, and each and every one is different. So we just have to be creative. That's why we also have very creative lawyers also in the Secretariat, working very closely with the lawyers in capital. So these are really the core of the challenges that the agreement gives us. But also, as I said, 30 years, and we have actually been able to overcome all of those challenges and made good solutions.
Just to add as well, that I know that regarding enforcement, both the EFTA Surveillance Authority as well as our member states, of course, have a really good working relationship with the Commission as well as with the member states, and that is something that people often. I mean, we are in the preparatory phase, but then of course, when it comes to enforcement and actually doing things, then there's a lot of cooperation that takes place, and we have really good working relations with the EU side as well as most of the member states, all of them.
Did you want to add something? Very good. And just to say that after the break, we do have colleagues with us from the EFTA Court and from the EFTA Surveillance Authority that will be speaking about enforcement, and they also have a breakout session. So they are going to try to charm you into theirs as well. The competition is fierce. I am going to allow, we had one final question. So, then we will wrap this up.
Yes, hello. Øystein Helleren from Norwegian Space Agency. I'm thinking early on where we can influence is being part of these expert groups, both learning about the discussions and influencing. How are we automatically invited as an observer, or do we have to be active finding these expert groups and knowing when they are started and ask to be invited as an observer? Thank you.
Yeah, I assume you're now talking about the expert groups of the Commission. Yes. That is actually experts sent from capitals. So normally these representatives of ministries or the ministry in charge of the file. But it can also be from like directors or anyone under the ministry as well. So I think if you're curious and if you're in a position where you work with something and wondering, maybe I should actually participate, I would go to the line ministry in your capital and talk to them. And I have seen as well when I participated in these groups before that, sometimes you have one from the ministry, but you also have others coming along. So that should not be a problem at all. But it's good to clear it with the ministry responsible of the files.
Yeah, just to add very quickly, we make, of course, the EFTA secretaries have these overviews as well of all the expert groups and the comitology committees where we are participating, and which we also consult and see with our member states if some has fallen out and some should be added to this list. But also in very general, like in our working groups, for instance, we also discuss regular, for instance, if we see or hear that there are meetings we have not been invited to, we of course then contact the Commission as well to make sure that we are invited to the next meeting. There's a lot of different expert groups meetings all the time, so of course that can happen that we fall out and we need to send reminders.
Very good. Thank you all so much for your questions. We do have here on a table outside this room what we call the 2-pagers, where we explain how EU law becomes EEA law, EEA relevance, adaptations, the decision shaping, our statistical cooperation, and also on our participation in the EU programs. We will have a breakout session on that as well in the afternoon. Sounds like we have 10, we only have 4. But now we're going to break. Please be back in here at 10:25. And for those online, I hope you also join us after the break. See you soon.